For the defendant's attorney that will come in trial. Are you Shannon Wilson?
Yes.
Mr. Wilson charged with 2 counts of aggravated possession of drugs, both 53 felonies. We filed a motion for intervention in lieu of conviction. Court ordered a pre-hearing report, which I did receive. I believe we had to continue this for a previous time because we had not had the information about his treatment. And then I did receive a fax on the 20th last week indicating that the person that provided is now in the Fayette Recovery Center treatment. And so we did have a hearing set last week, and we were able to have Mr. Wilson couldn't get sound from him. He was impatient and had some technical issues, so the matter was set today. And I do have the letter dated, well, actually, got dated January 19 from Fayette Recovery Center indicating that Mr. Wilson was in a, that recommended that he was eligible for intensive outpatient, but was resistant to employment, so they recommended him for level 1 application. And he should not be successful with that, then it would be recommended to go to ILP. All right. So I have then been presented, well, I previously had this the last hearing, and I kept it in file. Mr. Wilson is a plea of guilty and entry granting intervention in lieu of conviction form. Now this form consists of about 3 pages plus an entry, so there's 4 total pages. And on page 2 at the bottom, there's a sentence that says, I entered this plea voluntarily, and then right below that, there's a signature line with a signature dependent below it, and it says, looks like it says Shannon Wilson. And I'm going to hold it up there. Right. You recall going over this form and signing this form?
Yes.
And you did it with your attorney?
Yes.
Right. And when you signed this, did you understand that this was plea guilty, which means there won't be a trial?
Yes.
Okay. Now, have you had enough time to fully consider the matter for making this decision?
Yes.
Feeling with Russian pressure in any way in doing this?
No.
You entered into this agreement voluntarily. Yeah. All right, now, Mr. Wilson, I'm sure your attorney has explained this to you, but I need to do it for the record. First of all, normally when a person pleads guilty, the court then accepts that plea and then finds that person guilty. And then there is a sentencing hearing at which time the court can impose whatever sentence is appropriate under the law. That could be, in this case, 6 to 12 months on each count. Could be a fine of up to $2,500. Could be a suspension for private purposes of 6 months to 5 years. Could be community control, which means no prison time and supervision for up to 5 years, or any combination of those that the court feels is appropriate. If that happens, then that person then becomes, has a felony record, convicted felon, and it's on your record. Now, the procedure that's being requested here is a somewhat of an unusual thing in that, well, it's not unusual anymore, but it's different from the normal process, and that is that a person whose crime was a result of a substance abuse issue, mental health, alcoholism, etc., if they are in a certified treatment program, then the court can allow that person to plead guilty, but instead of finding them guilty, stay the proceedings. And a stay simply means they stop or they're frozen, and then that person is given an opportunity to complete an intervention plan, which is what you're doing at Fayette Recovery, and is put under supervision of the probation department under certain terms that are much less strict than a normal sentencing where a person's been found guilty and has a felony conviction. And that can be for a period of up to 5 years. This court, I follow usually 2 years. I think that's enough time to determine if the person is going to be able to deal with their issue and be successful. And then, even though you pled guilty, the court doesn't make any finding that you're guilty. So even though somebody might check the file and says that Mr. Wilson pled guilty, until you've been convicted or been sentenced, you're not convicted. And so you can still tell people no intervention. One of the other conditions requirements under the law is you must remain alcohol and drug-free for at least 1 year. Like I said, I said about 2 years, but you, the conditions are believe that you're not to do either of those things unless you have, for drugs, if you have a lawful prescription, those are appropriate, but other than that, no. Now, the advantage to you is this. Even though you plead guilty and you're not found guilty, if you successfully complete your intervention plan and if you comply with the conditions of supervision during the 2 years, then upon notice of that from the probation department, the court then dismisses your case, even though you pled guilty. And then what I do is I set the matter for a hearing to seal the record, and unless something happens between the date I dismiss it and the day of the hearing, I will seal the record. And then that means that it will be removed from public records, taken off of all the law enforcement computer records and police records and courts records, etc. And so that is a big advantage to you, is that you have this opportunity to avoid having a felony conviction. The downside is this: if you don't successfully complete your treatment program, or if you use drugs during that 1 year period or alcohol, or if you fail to comply with the conditions of supervision, then the court, the way that what would happen then is that the probation department would file a written notice that the court would be a motion filed by the prosecutor saying that the person that you have not been compliant, and then we have a hearing. And at that hearing, you will be represented by an attorney. And if the outcome of that hearing is that you have failed to comply, then at that time, the court finds you guilty, and then we'll proceed with the sentence. So that's the downside is that you don't get to try this program, and then if it doesn't work, come back and say, okay, let's have a trial. So that's why we have to go through this procedure. You understand that?
Yeah.
Okay. So because of that, I have to give you the explanation of the worst case scenario. Now, the agreement says that you're going to withdraw your non-guilty plea guilty to both charges, counts 1 and 2. Actually, that says count 1 twice on there. I'm going to change that to 2 on there. The record. And those are both aggravated possession of drugs under 2925.11 of the High Revised Code, both 53 felonies. Further states you understand that the possible penalties for that are a maximum of up to 12 months in prison. Each count, it could be a minimum of 6 months on each count. There could be a fine of up to $2,500, could be a license suspension of 6 months to 5 years. If you were convicted and sentenced to prison, the sentences could be ordered to be served consecutively, meaning one after the other. That means your total maximum prison term could be 24 months. You could have a fine payable of up to $5,000. You understand that? And you're not facing any felony charges anywhere else, are you?
No.
You're not on probation, community control, parole, post-release control for a felony in many jurisdictions. Now, in the event that at some point you should be found guilty if you fail to complete this program, I can tell you I ain't going to give you the chance to plead guilty. But if you don't successfully complete it or you fail to comply with conditions and you come back and we have a hearing and you're found to violate those conditions and you're found guilty, then at that time, the court doesn't have to sentence you to prison. I could instead impose what's called community control. Community control is regular probation. It could be for up to 5 years as well. Those conditions are more conditions and more strict.
Right.
The same procedure works as it does with this program. That is, if the probation department felt that you weren't complying, they would file a written notice at the court. We'd have a hearing. You'd be entitled to have an attorney. And if at that time the court found that you failed to comply, then the court could revoke community control and then sentence you to prison for 24 months and fine you between 6 and 24 months and fine you $5,000. You understand that?
Yeah.
Now, if that happens, again, I have to give you the worst case scenario. Then, upon completion of the prison term that was imposed by the court, the law provides that the adult parole authority may, at their option, put you under what's called post-release control supervision for a period of up to, in this case, 2 years. So they don't have to but it's up to them. The court has no involvement with that. And if they do decide to do that, then you'd be supervised under the terms that they set by a parole officer. And if during that period of time they felt that you were not compliant, then they would have the right, even though you served the entire term imposed by the court, to return you to prison to make you serve an additional period of up to 9 months for one violation. But there is a cap of half of whatever prison term was imposed for all violations. But if you commit a new penalty while you're under post-release control supervision, in this case, then in addition to whatever sentence the judge could give you on the felony conviction in the new case, that judge then could also sentence you to an additional period for committing that crime while under post-release control supervision in this case, 1 year or whatever time is left on the post-release control, whichever is greater or more. And if that occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that? All right, now the charges alleged in count 1, Mr. Wilson, that on or about March 17, 2021 in Highland County, Ohio, he did knowingly obtain, possess, or use a Schedule II controlled substance with hydrocodone. And in count 2 alleges the same thing in time and place, except the controlled substance was oxycodone. And again, both of those are aggravated possession of drugs, 5th-degree felonies, with possible prison term of between 6 and 12 months, possible fine up to $2,500, and possible license suspension 6 months to 5 years. Now, Mr. Wilson, do you understand what it is you've been charged with in those 2 counts? What the state said you did, when, where, and how they let you did it? Yeah. And have you discussed the nature of those charges, the evidence of the case, possible legal issues of the case, possible defenses might try to raise a trial, possible outcomes of a trial with your attorney?
Yeah. And
are you satisfied with his advice and confidence in this matter?
Yes.
Are you under the influence of any type of drug or alcohol at this time?
No.
Has anyone threatened you in any way to make you plead guilty here today?
No.
Other than being promised to be put into the intervention program to plead guilty, does anyone promise you anything other than that?
No.
Now, do you hold any license or certification from any state governmental agency that regulates any profession or occupation?
No.
You have to, since this is your last chance to stand on a non-guilty plea, I have to give you an explanation of all the constitutional rights that are involved in your pleading guilty. First, you have a right to have counsel, whose term of traffic is appointed to represent you. Now, that appointment wasn't simply to work the case out, but to provide any defense that may be available to you under the law that you wish to provide. So, you decide you do not want to plead guilty, they'll continue to defend you, including a trial if that's what you want. Do you understand that?
Yes.
Now, under the Constitution, you have a right to have a jury trial on these 2 charges, which means that a jury would be selected, a jury of 12 people would be selected from a group of citizens that live in this county that are summoned for jury duty on your trial. Now, after they are selected, the evidence will be presented, they be instructed on the law. Then that jury would have to decide by a unanimous verdict, and all 12 would have to agree as to whether or not the state proved your guilt in either or both counts. So it would have to be a unanimous verdict on each count. Now, if you decided you did want to have a jury trial, but you didn't want to plead guilty, you can waive the right, which means to give up, the right to have a jury trial. And in that case, you would have what's called a court bench trial, which means that instead of a jury hearing the evidence, the judge would be the one to hear the evidence. The judge would apply the law, and the judge would decide whether or not the state proved your guilt by proving beyond reasonable doubt on either or both charge. You understand that?
Yes.
Right now, under the Constitution, Mr. Wilson, you have a right to have to cross-examine, or no, I'm sorry, to confront the witnesses in open court and cross-examine them through your attorney. So what that means is that the witnesses would have to come in court and testify from the witness stand here in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney can ask questions. That's called cross-examination. First, that would be to try to bring out evidence that would help your side of the case. You understand that?
Yes.
Right now, under the Constitution, you have the right to use the power of this court to compel or force witnesses to come in court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily to testify at the trial, at your request, the court issues a court order that's called a subpoena, and that forces those people to come to court to be available to testify for you if you want them to, even though they don't want to be involved. And that's the same way the state's witnesses are forced to come into court to testify. You understand that?
Yes.
Now, under the Constitution, Mr. Wilson, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make a testimony. The prosecutor can, the judge can, you make that decision. If you decide not to testify, the fact that you did not testify not be used against you in any way by any person at any time. No one's even allowed to comment about it except in one situation, that is if there's a jury trial and you don't testify. The judge instructs the jury that because that is your right, they cannot consider that for any purpose. Do you understand that?
Yes.
Right now, under the Constitution, Mr. Wilson, you're presumed innocent until proven guilty by the state of Ohio on every essential element of each of the offenses charged. So what that means is that the burden of proof is on you to try to prove that you're not guilty of these charges. The burden is upon the state to prove that you are. In fact, under the law, you're not required to present any evidence in your own defense. Whether you do or not, the burden of proof remains upon the state of Ohio, and that burden is by proving beyond reasonable doubt every essential element of each offense, which is the highest burden of proof that's known under the law. You understand that?
Yes.
Right now, originally, Mr. Wilson entered a plea of not guilty to these charges, not guilty plea, denied the allegations, denied you committed any crime, and then exercised your vote all of the rights that I've just described for you. If you change your plea from not guilty to guilty, that is a complete opposite of a not guilty plea. The guilty plea admits the allegations in each count of the indictment, admits that their crime, that you committed that crime. That plea waives gives up all of the rights that I've just described for you, except the right to have counsel. Because you always have a right to have an attorney no matter what you plead. With that exception, your plea of guilty waives gives up your right to have a jury court trial, waives gives up the right to confront witnesses against you to cross-examine for your attorney, waives gives up the right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. It waives gives up your privilege against self-incrimination because you're the one saying you're guilty, that's what you find you guilty. It waives gives up your privilege against self-incrimination, as I said, because if you say you're guilty, that's what you find you're guilty. But it also then waives your presumption of innocence, which means that the state doesn't have to prove that you're guilty because you're pleading guilty, relieves them of that burden. Plead guilty subjects you to being sentenced immediately by the court if that's what the court's decision would be. It's not going to be in this case. And finally, it would waive give up any right to file an appeal that you think you may have had up until this point in the case. Now, if you should be sentenced at some point to the maximum sentence, or under other certain circumstances, you can file an appeal. Any appeal you want to file will have to be filed within 30 days of your sentencing entry being filed. You understand all of that?
Yes.
And are you a U.S. citizen, Mr. Wilson?
Yes.
All right, now, do you have any questions about the intervention and lieu of conviction process or what's expected of you?
Yeah.
You understand?
Yep.
Do you have any questions about the charges or the possible penalties?
Yep.
You understand those? Yep. Do you have any questions about the plea agreement? Yep. You understand it?
Yep.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
Yep.
You understand that?
Yep.
Is there anything you'd like to speak to your attorney about before you go there further?
No.
Do you have any questions about anything I've explained to you?
Nope.
And it's your decision to withdraw your not guilty plea, plead guilty to both of these charges pursuant to the terms of the plea agreement that we've just gone over.
Yes.
Right, then that's just count one, which alleges that on or about March 17, 2021 in Highland County, Ohio, you did knowingly obtain, possess, or use the Schedule II controlled substance of hydrocodone, violation section 2925.11 of the Ohio Revised Code, charged aggravated possession of drugs and fifth-degree felony, very possible prison term 26 to 12 months, fine of up to $2,500, and cost of license suspension 6 months to 5 years. I think this works. There's count two, which alleges the same thing, except that at the same date and time, except that the controlled substance of oxycodone, otherwise the same charge and the same penalty. How do you feel?
Good.
Thank you. All right, court finds on this date open court, defendants advised of all his constitutional rights made knowing, total, voluntary waiver of the same pursuant to criminal 11. Please accept the court file. Defendants found not found guilty because the court finds that he hasn't been. Well, first of all, that his drug dependence was a factor that led to this criminal activity, and that rehabilitation through treatment will substantially reduce the likelihood he will commit any further criminal offenses. He has been accepted into an appropriate certified treatment program. He's otherwise eligible for controlled sanctions. He's not a repeated dangerous offender, and is otherwise eligible for intervention in lieu of conviction as set forth under the statute. Therefore, it is ordered the defendant's plea of guilty is accepted. However, there will be no finding made at this time of guilt. Rather, this case will be stayed pending the report from the state and probation department as to the defendant's progress in the program. Defendant will be placed under controlled supervision of the probation department of the term set by the court for that program for a period of 2 years. Defendant is required to successfully complete his intervention plan with fast recovery, including the requirement that he abstain from using drugs or alcohol for a period of 1 year. Obviously, the exception of drugs is those that are lawfully prescribed. One of the conditions is you have to give them a copy of a prescription, a lawful prescription, as soon as you receive it. You're also required to pay the court costs and any programming fees. And in the event that you do successfully find, again, required to comply with all conditions of the probation department for this program that's been approved by the court. Now, if you successfully complete your intervention plan and obey all these conditions, then that court will thereafter, upon notice of that from the state and the probation department, will dismiss the charge against you and will set the matter for a sealing hearing to determine the record will be sealed. In the event that you fail to comply with these conditions, then upon written notice from the probation department filed with the court, and the copy of which will be provided to you, the court will conduct a hearing at which you will be represented by an attorney. If the outcome of that hearing is that you have failed to comply, then at that time the court could terminate you from the program and find you guilty, and then would proceed with a sentencing hearing at a future date. All right, is there anything further from counsel?
There you go.
Only, Your Honor, I think he's ordered to report on Wednesday by the probation department. I didn't know if you need to go down there today or not.
Well, I can go down today and see if you can see them today. I don't know what their schedule is, and if that's the case, we may not have to do it Wednesday. But, you know, if they're not available, I don't know what their schedule is. Of course, with COVID and everything, you know, it's hard to say, but it would be worth a shot to go down there and see that you wouldn't have to make another trip.
Okay.
All right. Anything further?